Would you like us to go ahead and get started now, Michelle?
Yes, let's start.
Okay, perfect. I did share that we do have our public webinar this week. It is on Wednesday with Michael Burns on taking statements of employers, injured workers, and witnesses. If anybody needs CE credits or wants to hear about that topic, you can register for it now on our website. I also shared that we do have our 2026 PD money chart available. I have uploaded it in the resources section here today. You can download it. And also, if you want a laminated copy at home, just shoot me an email with your mailing address and I will mail you one. They came in yesterday and we are mailing them all this week. So you're welcome to have a laminated copy if you'd like one. And we also have Nikki here. And I'm Nikki, I'm so sorry. I'm going to have you say hi again. You don't have to reshare your fun fact, but it's so good. I kind of think you should. But anyway, it's up to you, Nikki.
Well, good morning, everyone. My name is Nicole Zaylor. I go by Nikki. I am in the Woodland Hills office. I am located in Orange County. I will go ahead and share my story again. It is about sharks. I don't know if anyone else is afraid of sharks. I have always been terrified of sharks. My brother and I were on vacation last year in Hawaii, and we got the brilliant idea to conquer this fear. We would go shark tank diving or cage diving. Well, we did it. And I can say it did not overcome my fear of sharks. I still am afraid of them and will not be doing it again.
I love it. Thank you,
But I
Nikki.
do look forward to working with all of you on the current files and future files.
Thank you, Nikki. And yes, you are absolutely brave because there's no way that I would be overcoming my fears by jumping into a shark tank. It's just not, that wouldn't happen.
Is it okay, since we're starting about 15 minutes late, that we go about 15? Is it okay to go to 11:15, Michelle?
Yes, we're
Okay.
good. If anyone has to hop off, well, they can listen later.
Perfect. Okay, perfect. Okay, Sherri, you're
Okay.
up.
All right. All right. So I'm Sherri Dozier, and great to meet you. And I just a little bit of background. I have been in the industry, and I'm a young person, but it's going to sound like I'm really old. I've been in the industry for 38 years. I was on a claims desk for a period of time. I was a supervisor and a manager, and I've been with Bradford Barthel for about going into my 27th year, actually. So part of what I do is training. I also am a specialist in audits, and that happened about 24 years ago when a friend asked me to help them through an audit. And Tom Bradford, being the generous guy that he is, said, yeah, go ahead and help your friend through the audit. So I spent a year helping my friend through an audit. It was a very difficult audit, but I learned a lot and have taken it forward. Seems like auditors change their stance on what is the proper procedure every couple of years. So it's good to keep up with this. I have some interesting things I think that I can talk to you about. I've been helping a couple clients through an audit. One in particular, there were auditors on this particular audit that were doing things that I hadn't heard of before. So I don't know if it's a trend for the future, but I'll try to point that out. Anyway, so here we go. We'll go through this real quick. So the main point, we're going to talk about calculating earnings, and we're also going to talk about some issues with benefit notices, some tips that may help you. And that's kind of the two things that we're going to do today. We have other topics on our next training, but earning capacity really is the goal. And I think that, sometimes even when I was a claims examiner, I would just get down to the nitty gritty and look and think, okay, what's an average? I'm going to just add all the numbers together, and then I'm going to create an average. And really that is not the way we do it now. And that's not the way that auditors do it. So it's earning capacity. If you looked at your own salary, let's put it this way, and you were to say what you averaged, you would look at the totality of your earnings because you'd say, no, I averaged this. So I think it's the same thing, is you need to look at what your true earning capacity is. And that's not that we're trying to pay them the most money. What we're trying to do is pay them the accurate amount of money. So how would you define it? Is it a mere average? And what period should be used to create the average? And that is some difficulty that I see with some of the claims teams that I work with. What periods do we use? So in practice definitions, earning capacity is defined in the case of Montana, which is very old. There's also another old case, thrifty drugs. And if any of you are in my same genre, which it may not be, thrifty drugs was the case of the several decades. And we'll talk about it so you get to know what it is and you'll see the concepts of it. But now there's a new sheriff in town, as I say, and that's Grossmont Hospital case. And that deals with earnings that are beyond the date of injury. For example, if someone gets a raise beyond the date of injury and that raise was already known to going to be happening, incorporating that sum or that level of benefits is more towards the earning capacity than maybe if you just average things. So we'll talk about how that's done. I'll kind of share with you a few things that have happened along the way with the auditors. So they're looking for Grossmont, and they also always follow Montana. So Montana and thrifty drugs, Montana speaks to the period, which we were just talking about, of employment being the guide for what periods should be considered in calculating an average weekly wage. I'll give you an example, and this is easier when you have like part-time workers or seasonal workers to understand that maybe they have a season that they work and you consider the period. But even in regular calculation of average weekly wage, you want to consider the period. What a period applies. What was the intention of the employer? Full-time, regular, what are you looking at there? So always kind of look outside the box and think, what period are we looking at? But certainly don't cut off the period for a seasonal or a part-time worker if they were promised to work, another 6 months. You need to look at what the real wages would be. Moving on to thrifty drugs, and this is a really old case, but it's a good example, and that speaks to earnings beyond date of injury again, but it applies to a loophole under 4453C4. In thrifty drugs, it was called 4453CD, but that they changed it to C or D, and who knows why they did that. I think they just like to have fun with changing things occasionally. So it kind of says the same thing. So welcome to the party of Grossmont. Grossmont Hospital speaks to earnings beyond date of injury, but applies to the loophole under 4453C4. And you will know really more about this as we go through the presentation. I like to start off with this because this is a major factor in wage calculation right now, is looking at the exposure of even earnings beyond date of injury. Even if you're not a union employee, and your employer regularly gives you raises, and the time frame for the raises in Grossmont, it could be shortly thereafter the date of injury. In thrifty drugs, it actually was, if there was a promised raise, this individual got a raise for like 3 years until she was at max TD. So they no longer really follow that, although it's not, forbidden, but they follow Grossmont now. I think it's a better way to calculate the benefits, because why should an injured worker get a raise every single year? Is that truly their earning capacity when the date of injury is a year ago? Probably not. So I think the legislators and the legal experts out there kind of knew that they needed to create a new situation. So here's some food for thought. And anytime you have a question, please ask me, just interrupt me, just say, hey, I have a question, because I have about 65 slides, somewhere in that range. We have plenty of time for questions. And if I don't have the answer right away, I will get back to you. So food for thought, it's an average yes. But if there are weeks that are hours that are unusual due to illness or leave of some type, usually like a medical leave of some type or some type of illness, where truly you can see, let's say they make $900 a week normally, and all of a sudden you see a week that it's $400. What is that week about? I would look at that carefully, and I would see, is that their earning capacity? So question yourself on that. Don't just automatically say, well, I'm just going to include that. Sometimes you can include it depending on the type of work that people do, but other times you probably should exclude that. And I can tell you that the auditors will exclude it if it looks like it isn't within the realm of possibilities for earning capacity. So I recommend, of course, that you consider removing the periods from your calculation unless the type of work is subject to economic factors. And there are a couple cases. I don't know if you have construction workers or work in your inventory of business? If you do, let me know. I'll send you some things on this because construction work, and I found this out in the most recent audit, there are some laws that say essentially that they're not really promised full-time regular, that it depends on the economy. It depends on, is this a good economy, a bad economy? It depends on the weather. It depends on what kind of construction they do. Are they inside or the outside? So that those are factors. But in that type of work, you count the weeks that for the whole year or for the period that was promised. So if they were promised, a year and they worked only 9 months out of the year, but the other months they didn't work because maybe they took off for the holiday and it was slow during the holiday, there was no work, or the economy was a downturn, like certainly we saw in COVID. Those are factors you can take into consideration and actually incorporate those weeks into your calculation. Be careful about it. Make sure that there's a consistent pattern. I would look at the year before, and if the year before they had the same similar periods of downtime, for example, during the Christmas holiday, I'll see from maybe mid-December all the way through middle of January, a lot of construction companies kind of have nothing really going on, and so a lot of people are off. But that is a part of their earning capacity because that's the regular practice or pattern of receiving earnings. Much like I have another case right now, and we actually are in appeal and we're disputing the audit unit. That we had a gentleman that it was a construction type of work. It was more farm work, but he did some construction type of activities. But that really wasn't what we were looking at. We were looking at, he worked full time normally, but this one particular time, and he'd done it on other occasions, he came into work and he had his toddler and his infant child. And he asked the foreman if he could leave them in the trailer by themselves. And so, the foreman said, hey, we can't do this. And this is actually a real story, and it's hard to believe that someone would do that, but maybe he just didn't know what else to do. And he's actually a very nice man. I've spoken to him, but he was told by the foreman that, no, can't do that. You need to go home, take care of your child care, issues, and then come back to work. So he went home, and a couple hours later, he called his foreman. He said, I'm having problems with childcare. I'm going to take time off. He ended up taking about 5 months off. And it was in the year, where you would consider 1 year back from the date of injury. So it was our contention that year should be, or those 5 months should be included in the average weekly wage because he removed himself. And that really was his earning capacity. He didn't have any other earnings to consider. And it wouldn't really be fair to our employer if they had to pay a higher wage when that wasn't his earning capacity. The interesting thing on this is this gentleman agrees. He's even willing to write a little letter to the audit unit to say, no, I removed myself, which is really to our advantage. But the auditors on other files, because we had a book of construction cases on this particular audit, they removed situations, but the highest amount of weeks or a couple of months that they would remove was 3 months. And the case law really doesn't limit it to 3 months. It's really if they remove themselves, then it's not fair to the employer to not count them in to the earning capacity because that is true earning capacity. So look at the most consistent pattern of earnings and what is the employer's promise? Well, that employer promised full-time regular work, and this gentleman was busy all the time. So it's going to be fascinating to see what happens on the appeal. The administrative director has not answered yet, so we're not in our WCAB appeal. I hope that the administrator, they take a look at it. I know they've changed hands. I think it's a woman now. It was a gentleman before. And they have a tall order, and they try to keep the law, as accurate as they can. So I understand an auditor can find something, and they feel that that's, our auditor said, well, that's too much. That's not a legal term. That's too much. That's not a legal reason. And there's not a lot of case law on this, but there's a couple of cases that really try to guide us. So consider all sources of income. Earning capacity is the goal, of course. Concurrent employment is a big thing. You have to ask the questions. I know when you do, I'm not sure if you take statements, but at least in your initial interview of the injured worker, you talk to them. Do you have any other employment? Do you have any other earnings that you regularly receive? And usually they'll tell you, yes, I have a part-time job, or, I have this other source of income. And so you want to know that because, and also a raise during the 1 year period prior to the date of injury. And that raise is promised because even though Thrifty Drug and Grossmont Case don't specifically mention a raise during the 1 year back from the date of injury, it's incorporated in because it takes you to the fourth method of the calculations of wages. And we'll go through those in detail. So here we go. So there's three main methods under 4453C. And then there is a loophole. And this is what I'm talking to you about, 4453C4. We talked about it in Thrifty. It also applies to Grossmont. So the first method is full-time regular. And on the employer's 50/20, a lot of them will mark full-time regular and just a common box. And sometimes you'll look at the wage statement and you'll say, they're not full-time regular. They're maybe working 20 hours a week, So the definition of full-time regular is where the employment is for 30 or more hours a week and for 5 or more working days a week. So that's kind of the definition. And the average weekly earnings shall be taken at the number of working days a week times the daily earnings at the time of the injury. So that's kind of the method that you look at. And when you're looking at a full-time regular person, you really are looking at earning capacity. They're full-time. So those weeks that I said you may want to think about removing, they're kind of promised these hours, at least, the employer saying they're full-time regular. So regular hours, regular working schedule is what we give them. So if they have a week that's really short, then you should consider removing that. I know I can tell you for sure that if the auditor looks at the 50/20 and they see full-time regular and they see a couple of weeks that are not, don't depict that, they will remove those weeks. So method 2 is 2 or more employers, concurrent employer, where the employers are working for 2 or more employers at or about the same time of the injury. So not a year before, not a year after. This is like this income happened in a similar time frame. I've had a couple applicant attorneys try to say, well, they had concurrent employment, and I think there's a few days in the last year of injurious exposure, and they wanted us to incorporate it in. But our argument was that really didn't depict their earning capacity, and we actually prevailed on that. So a similar time frame as the date of injury is what you're looking at. So average weekly earnings shall be taken as the aggregate of these earnings from all employments computed in the terms of 1 week. So earnings from employments other than the employment in which they are participating in that they were injured on shall not be taken at a higher rate than the hourly rate paid at the time of injury. This is important to know because sometimes you'll get, a check stub. And as long as that check stub tells you what the hourly rate is, then you kind of have an understanding of how much the other employer was paying them. You need to find that out because let's say, for example, your employer pays, I'll just use a sum of $20 an hour, but the other employer, because it was a different type of work, pays $23. So if you use the 23, you're going to have a much higher earning capacity than your employer actually provided for them. You want to incorporate the earnings in, but you would use the hours of that other employer earnings times the rate of your employer. You don't include overtime in that second employer. It's just the straight hours that times your employment rate. So easy application of 2 or more employers. Use your internal printout to determine how many regular hours, overtime hours, and on your employer in particular, the remuneration. Like, for example, did their employer provide a apartment for them because they were, that was a part of their earning capacity? Do they receive raises? Do they receive bonuses primarily? Is there something that actually is a benefit to the injured worker or to the employee, excuse me, and not just the employer reimbursing them from something they paid for? It has to be an extra thing, benefit to that employee. So request and obtain additional employer wage information and determine total hours, regular overtime, something else, the bonus or whatnot. You may or may not get it. So usually what I would say is try to get the check stubs. A lot of times that injured worker can tell you, where I work 20 hours a week and my hourly rate is such and such. And you can use that and still try to get more information, but then you're considering that other employment in your average weekly wage calculation. So it is the members, we call them members' burden to provide other earnings. So that's the injured worker, that's the employee's burden to provide the other earnings. And usually they're happy to do that. You just have to ask the question so that they know they're entitled to do that. So ask for what they can provide, and this is what I was just saying, and then do your best to determine the hours worked for additional, regular hours on this one. And you can note the secondary employment rate, but you don't consider that, only your employer's rate that you're going to use to calculate all of the hours. So it can be kind of complex, but I think you can simplify it by just doing the best you can to get the information. And I think the employees are all too willing to give it to you. Even if they give you a couple check stubs, you can tell that they are working for this other employer. So let's do the math. So total all regular hours times your employer's rate, total all of your employer's overtime hours at your employer's rate. So that means you have an overtime rate, you have a regular rate and an overtime rate. You want to include the overtime rate when you're calculating overtime. And total all the bonuses and extras that benefit the employee from your employment. And that is the way you're going to come up with a combined result for the best you can tell what the earning capacity would be. And just document it. Document how you came up with that. Auditors really look at that. They look at the documentation. They didn't have anything to offer me. I saw a couple of check stubs. And so they told me that their regular time with this other employer is 20 hours. And I use my employer's rate of pay. If the other employer is less than your $20 an hour, let's say they make 18, 19, you certainly can use the lesser rate. You just cannot use a higher rate. So hopefully that certainly would make sense. So here's what is important. This kind of goes back to some of the case law that we're talking about. Divide the total by the weeks being considered. This is like Montana. If you have earnings for 52 weeks, use 52 weeks. Or if you have earnings for 6 months, use the 26 weeks. Really look at the accuracy. And this is the normal thing. Construction is a little bit different, and we can certainly, as I said before, we can look at that if you have an example of a construction case that you'd like to offer, and we can talk about that. So method number 3, irregular piecework and seasonal. So if the earnings are an irregular rate, it's piecework, like they're sewing so many pieces of clothing during a certain shift. If it's commission-based or are specified to be by week, by month, or other periods, or seasonal, then the average weekly earnings mentioned in the subdivision A, that main section, shall be taken at the actual weekly earnings average for a period of time, not to exceed the 1 year, as it may conveniently be taken to determine an average weekly rate of pay. So you need to look for the real true time frame. It doesn't mean, I've seen examiners still saying, okay, it's 1 year. So they take whatever earnings there are and then they divide it by 52 weeks. And that's really not what we're doing. That was maybe back when I started in the middle 80s in claims. And back then, that's what you would do. You would do it differently. You take 52 weeks, and the labor code actually said that. And I think some of us who've been in the industry a long time, if they have been away from the desk for a while and they come back, they may think that it was 52 weeks. It's really not that. The case law kind of supports it's for the time that you're considering. So if they are seasonal workers, You want to really look at that. And also seasonal workers, to end benefits, you need to make sure that the season would have ended and they have no other earning capacity afterwards. Like my favorite season really is strawberries because I am a strawberry lover. So I think that ends in July. And I believe, if not, I'm not mistaken, that lettuce is the next season. And so if they, with that same employer, if they have both of the seasons, or with another employer that they do regularly have the lettuce season, you could be looking at a wage loss situation, or you could be, because they're losing those earnings from that additional promise of earnings. So Argonaut, which we've already mentioned, it's a Montana case, and that's an old 1962 case. So California Supreme Court case on earning capacity. And this really is one of the better cases for earning capacity. Consideration must be given to the entire work history. What is the earning capacity during the time of the injury? So that's why you incorporate other employments. That's why you incorporate something outside of the original date of end loss beyond it, because if those raises were promised, or if they had an additional season, why you don't discontinue the benefits. And reflective of why we should use the season promise when we consider wage calculation. So if all of the factors above have been considered and the season ends without any further earning capacity, then you can consider ending the benefits. But you should know the answers to everything that I've just spoken about, and you should document it. Because if you end the benefits and there was other earning capacity, you're going to put yourself in a comp due situation or penalty situation. And I know that that's why you're here. You don't want those things to happen to you. So an en banc decision on irregular seasonal work. Signature Fruit Company was a big case. And that was in 2006. And then Jimenez versus San Joaquin is in 2002. It's a case before that. And those are guiding factors. So irregular work or seasonal work should be calculated as an average over the promised period of work. It does follow Argonaut and Montana, not to exceed 1 year. And so that kind of is the gold standard, those three cases in particular. So here's method 4, and this is what I call, this is my term, the loophole. I've heard some auditors say the loophole, but I do think they use it as if it were a loophole. So it's method number 4. And it says where the employment is for less than 30 hours per week, and here's the key, or where for any reason the foregoing methods of arriving at the average weekly earnings cannot reasonably and fairly be applied. And we're going to look at Montana and Thrifty a little bit more, but you'll see that the raise or the different circumstances that happen would be a loophole. It would take them out of the normal 3 methods. So average weekly earnings shall be taken at 100% of the sum, which reasonably represents the average weekly earning capacity. That's at the time of injury, and due consideration being given to the actual earnings from all sources and employments. So common mistakes, not verifying if the employer paid the entire wage for the date of injury. Okay, I've seen that over and over again. And, you start your waiting period differently if they have not been paid for the entire earnings for that date of injury. So it's important to know, because you can be off, the payments by a day, and you don't want to do that. Miscalculation of the waiting period usually happens when you don't know if the date of injury was paid for. Not following up on concurrent employment earnings, so not asking those questions, not getting information on that, not putting the burden on the employee to give you something. But even if they tell you, I know I work 20 hours, and you're asking them for the information, you may want to consider that. If they can provide you something that says, yes, I do work for this employer, and I'm telling you I work 20 hours a week, so forth. So just be careful. You don't want to give money away for nothing. But if you can reasonably come to the determination that these individuals do work that second job and work 20 hours a week, then I would incorporate that in the earning capacity. And do not consider a raise during the 1 year prior. If you don't do this, consider the raise during 1 year prior to the period of the date of injury or shortly after the earnings. That's the Thrifty Drug case. That's the Grossmont Hospital case. And those are things that really will, as far as when the auditors are looking at wage calculations, and I'll give you an example of something that they did most recently. And I cautioned a client on in different occasions on this, is this individual had 3 raises, and it was in a period of a year. Actually, usually it's a raise every year that it gives you the information to say, well, there's likely a raise coming up. But this person was doing so well that they had 3 particular raises. So that last year of, the 1 year back from the date of injury, there was, I think it was $26 an hour, there was $27, and then there was like 3 or 4 months before the date of injury, there was $28.50. And so the question you have to ask yourself is, what's the actual earning capacity? If you look at Grossmont and you look at Thrifty Drugs, they would share with you that the earning capacity is actually $28.50. That's their earning capacity. So in a situation like that, you would look at all of the hours for the period of time that you're counting, and you would use the new hourly rate plus that overtime rate to calculate your average weekly earnings. And that is what the audit unit is doing. And you can see why sometimes when you're in an audit, you may have a big discrepancy and the auditor is finding such a higher rate than you have. But that's why they're finding that higher rate. They're looking at earning capacity. And if they had a raise during that last year of, prior to the date of injury, or if they had now with Grossmont a raise shortly thereafter, and it changes their earning capacity, that is why you're having a discrepancy. So create consistent rules of understanding. It sounds like we're in a union and we're creating that, but your office, if it can flow together in your consistent rules of understanding, like you understand you're going to look and consider Montana, you're going to consider Grossmont Hospital, Thrifty Drug, and you're going to look for those outlying factors. What is actually happening here to look at the earning capacity? So if you have a process in place and that has a common understanding, then you will have a consistency in your wage calculations. And that's not just for the individual, that's for your office. Audits are lost and they are won in the consistency of the claims team, claims operation. So here's an example. Hopefully I didn't give this already, but recent audit, one auditor found amount of comp due. Second auditor, this is a funny story. This is my most recent audit. It was kind of a circus clown show with them, but anyway, so one auditor in particular, he was the supervising auditor, he found a certain amount of comp due on a particular claim. And we were disputing this anyways. We had a different method of calculating, and he was kind of going outside the rules or whatever. The second auditor came in and re-audited the same file. Now, why would they do that? Who knows? And she found a different amount of comp due. So then the same auditor that audited the first time, that started this whole ball rolling, he re-audited the same file and yet found a different amount than he originally did. So if you were consistent in your rules of understanding, just know that maybe they're not going to be. It may be something you want to dispute. So it's not uncommon for them to be inconsistent. And what I'd ask you to think about right now, let's say you look at a file on a particular day. And let's say you come back to the file maybe 2 weeks later, a month later, or whatever. I will promise you, because I know that I've done it, you will see something different in that file a little while later than you maybe saw the time that you were looking at the file. Maybe your focus was different at the time you originally looked at the file, and then you looked at it a few weeks or a month later. But the auditors are supposed to capture a moment in time, and they are supposed to be consistent in their methodology of auditing files. These rules apply, and the benefit of the doubt certainly goes to the injured worker. But if you have documented your reasons for why you did what you did, your reasons should be considered as long as they are in the realm of understanding. Auditors usually don't agree with me on that, but in the long and short of it, on many occasions since, gosh, it was the early 2000s, I've prevailed on those aspects. So, question: which auditor is correct? Is it the first one, second one, or another try by the first auditor? And the answer is who knows. There was not a consistency in their office regarding the application of the rules to determine wage calculation. It was they looked at the file and they said, well, I see this. The other one said, I see that. And this is a good thing. In fact, we'll be using this in our appeal, that if you have a file and you determine one earning capacity at one point, in a period of a week this happened. This wasn't like it was months later, so the same information was available to them. Then a second auditor audited and found something different, and then the same auditor came back. How is their credibility on how much they're saying that you may owe in comp due or penalties when they themselves, between two of them, cannot even determine what the actual average weekly wage should be? So it's something that you can dispute if that situation ever happens to you. Actually, I've never had it happen to me, so it's a fun thing to share that this could happen too. So wage calculation is not a perfect science. Any one of you in your own office, let's say a day later, you look at a file and one of your coworkers looks at a file, you may see it differently, and that's okay. But if you're in the realm of reasonableness and using and applying the rules, you're going to be in a similar range. So you can see by my example of the audit team, two auditors found different results in 3 attempts. And the audit team did not follow what I'm suggesting, which I know you're following. I'm sure you're following it, and you're going to follow it. My suggestion is creating consistent rules of understanding for wage statement calculations, and all based on earning capacity and the methods 1 through 4. So a few more important thoughts here. When calculating a wage statement, determine if there is a consistent pattern of wage increases, or a wage increase that was during the 1 year prior to the shortly thereafter. And that is the earning capacity. So you want to look at that increase and then maybe look at the number of hours and calculate your earning capacity from there. It's not just an average then. And I know that is a common thing that happens. It's like, well, I just included what was on the wage statement. Well, that really isn't the way to do it. Your understanding and your consistent pattern should be looking for earning capacity. And if I help you understand nothing more than that on wage calculation, then I think that we have a big success here. So look at earning capacity and just use all of the factors that we're talking about today to make your best judgment. Auditor may still disagree with you, but if you have your knowledge of why you did it and you're documenting it, I think you're in pretty good shape. So consider counting the weeks that most reasonably reflect their earning capacity, and some exceptions would be construction workers. One point I want to make as well: if someone earns a bonus, you do not count that as an extra week. I've had several examiners think, well, that's more earnings, so I'm going to count an extra week. You don't do that. That's a bonus. That's just part of their remuneration. That's part of the gift that the employer gives and they earn, under their employment agreement, that they're going to get bonuses. So you just incorporate that sum. Let's say $800. You incorporate that into the earning capacity, and you only divide by the amount of weeks that you're counting. So let's say you had earnings that were actually weeks worked and not a bonus for 52 weeks, you count that. Or if it's lesser than that, you count those weeks, but you always incorporate that bonus in the sum of money that they made that period. So let's go into, are there any questions so far? Or, well, I told you can interrupt, so please interrupt. So once upon a thrifty drug case, and thrifty is not really used like Grossman is, but I want you to have an understanding of it to see the difference between the two, because I think it'll give you a better grasp on what really is earning capacity, what should I be looking for. So it's the loopholes created by cases that lead to different applications of the law. So a little bit of history lesson on this to make the point. And do we all love the ice cream? They sell it now in the grocery store. I thought that was fun. So case fact pattern. So injured worker while working employed by Thrifty, and she was a retail clerk on March 22, 1971, long time ago, sustained an injury to her back, and it was compensable, rising out of and occurring in the course and scope of employment. So on the date of injury, earnings were at $131.20 per week, which would result in a temporary disability rate of $81.02. I'm fortunate to say I don't remember that low of an earning, but but I've been in the 80s, so I do remember a lot lower of earning capacity. And it's fun to present the facts on this because it's hard for any of us to believe, that something would be so low when you can spend $131.20 on a meal easily with 2-3 people. So that's how we've changed. So in this particular case, there was a union contract that provided for wage increases for union members in the form of increments in the hourly wage. So their hourly rate was increased based on the union contract. And that's a big issue here. If they have a union contract, you really need to know when are their raises promised. Because in that situation, and we'll go into Grossmont, but let's say they had a raise promise that was going to happen a couple of weeks later within a month period of time. That really is their earning capacity. So should they be held to the lower rate? Grossmont says no, and even Thrifty Drug says no. So that's kind of what you have to consider. Okay, I read that. So under the union contract, the applicant's weekly earnings would have increased in July 1971 to $138, which would have resulted in a temporary disability rate of $86.22. And then in July of 1972, and here's where you're going to see the difference between Thrifty Drug and Grossmont. Grossmont considers the time frame just shortly after the date of injury. Thrifty Drug actually followed the increases per year, because they said Thrifty Drugs found that that was the earning capacity. So in July of 1972, her weekly earnings would have increased so that the temporary disability rate would have been increased to $87.50, and that actually was the maximum temporary disability rate at the time. So the question is, let's say in 1973, she was still in this claim, would you have given another raise? And by the definition of what Thrifty Drug found, you would. You never pay beyond max, but if it was under max and you had a sum of money that you could provide and then you got to max, you would do that. So in Thrifty, the applicant worked 30 hours or more and 5 days per week. So what method would you use? Would you use method number 1, full-time regular? Method number 2, 2 or more employers? Method number 3, irregular earnings, seasonal work? Anybody have any thought? You can turn on your speaker. I'll do the waiting. Okay, I'll move forward. So actually, the answer is none of the above. The fact pattern, because of the raises, ended up opening up that loophole of 4453C4, even though she was a full-time regular employee, and we could say, yes, number 1 was accurate. She didn't have any other employers, so number 2 didn't count. She wasn't irregular, seasonal, so forth. But she was subject to a different circumstance because she had a further earning capacity through her contracted raises. So subdivision 4453D, and that was at the time of that 1979 Thrifty Drug case, provides that where the employment is for less than 30 hours per week, and even in 1979 it said this, or where for any reason the foregoing method of arriving at the average weekly earnings cannot reasonably and fairly be applied. So even in older cases, that same theory of if it is outside the 3 main methods, the 4th method is you're going to do something different. So the average weekly earnings shall be taken at 100% of the sum which reasonably represents the average weekly earning capacity of the injured employee at the time of the injury. So those raises, as I was saying, the one particular example of $28.50, that's the earning capacity. And so you look at that to calculate your average weekly earnings. So earnings were litigated in this particular case, and the defense argued the calculation of average weekly wage was to be in accordance with Labor Code 4453A, actual earnings at the time of injury. And the applicant argued that they were entitled to 4453D, which is now C, calculation of earning capacity, using earnings post date of injury because there was a union contract in place and that was promised. So here's what the court said. The court said, it is to be noted that while both subdivisions A, which is actually full-time regular, and D, which is now C, have the common objective of determining average weekly earnings, subdivision A reaches that objective on the basis of actual earnings, while subdivision D speaks of earning capacity. When you look at the prior case law, the Montana case, earning capacity really for decades and decades is the standard. So that should be your common understanding. When you're creating your team to say, how are we going to do this so that we're consistent? That should be your common understanding. So the audit unit's application of Thrifty, this is how they used to do it years ago. So Thrifty speaks to earnings beyond the date of injury, much like Grossmont, which we'll talk about. And what about Thrifty's application to actual earnings during the 1 year prior to the date of injury? So the loophole applied, and this is what the auditors found, and it opens up the issue of earning capacity, arguments for the applicant who received raises during that 1 year prior to the date of injury. So the applicant may not have had the raise for the entire year, but the earning capacity carries the day and the promise. So what the audit unit did is they used the earning capacity and they applied the raise. This is what they used to do. They don't do it anymore from the raise period forward. So let's say, for example, you had a raise and you had 6 months prior to the date of injury. They would only count the 6 months at the new raise rate. And that would be how they would do it. So we were all on that path. And we thought we had it down pat, and we were doing well with the audit team because we knew how to do that. And then they shifted, and we'll talk about this as soon as I finish this, to the Grossmont. Grossmont was the shift. So the loophole gave way to interpretation, and that's what 4453C, does. It gives the interpretation to the person that's looking at it. When the audit unit's looking at it, they're going to always look at what the earning capacity is in their opinion. So prior to COVID, every audit I participated in really looked at Thrifty as using the raise rate and only for the period of time that the raise counted for. So if they had a raise for 2 weeks, they would use the hours worked in that 2 weeks and they would times the raise rate, and that's what they said was the earning capacity. So here is along came Grossmont Hospital, and it addressed earnings post date of injury and under the disguise of earning capacity. So Grossmont deals with raises post date of injury, as we've been talking about, our obligation to apply that raise in an average weekly calculation. So it clarifies if the earnings were anticipated prior to the date of injury, then the post date of injury earnings can be considered. If not, this is where it's really good for you, then they are not considered. So someone who tries to say a month or two later, hey, I got this raise and I knew about it, this is saying it has to be in close proximity. So if it's a month after, the date of injury and they were able to share with you, look, they've already promised me this raise, you may want to consider it. I would consider it in the wage calculation. But if I've seen applicant attorneys come down the road, 3 months later and say, well, they got a raise, you should be raising the average weekly wage. And that is not correct. They're using Thrifty, the old Thrifty. So I like to say there's a new sheriff in town. That is the standard. And I will tell you after I go through this an interesting story, because this started probably a couple of years ago where the audit unit was really using Grossmont Hospital, and the clients that I was working with at the time, they would have comp due because of this. They were looking at Thrifty. They were looking at other situations. They weren't used to Grossmont, which was really an unused case at the time that we knew about in the auditing world. So Different times, different interpretations. I think the audit team has a meeting and says, what are we going to apply this couple years later? And they want to keep us on our toes, which that's okay too. So Grossmont, although like Thrifty, defines earnings post-date of injury to be considered if there was a promise or a reasonable expectation of an increase. The audit unit has expanded its application with the use of 4453C4 other methods. And in cases where the applicant receives a raise during the 1 year prior to the date of injury, the audit unit applies Grossmont. Now, here's how they do it. I've kind of been talking about that. They take all of the hours worked during the 1 year prior to the date of injury and multiply them times the raise hourly rate only. That means the overtime raise rate too. So it's a normal, hourly rate. So if they went from 20 to 22, you would use the $22 normal rate, and then you would use whatever the overtime rate is for that calculation. So what else must be considered in the calculation of earnings? And then that is 4454. And I'm sure you're familiar with this, but this is kind of just a catch-all that we want to make sure you're looking at all the aspects. So in determining average weekly earnings within the limited fixed, the 4453, there shall be included overtime, the market value of board, which we kind of talked about. If they're someone who manages apartments, what is the market value of that apartment? So it isn't like what they're receiving or what they say they're receiving, it's the market value. If it's worth $1,400 a month, that's the market value of benefits that they're being given by their employer. Lodging, fuel, and other advantages, and keep the word in mind, advantages. It has to be an advantage to that employee received by the injured employee as part of their remuneration, which can be estimated in money. So it has to be something tangible. And then such average weekly earnings shall not include, and here's what you don't include in that, any sums which the employer pays to or for the injured employee to cover any special expenses incurred while they're working, in the employer's business. So if the employer reimburses for gasoline, it's an advantage to the employee, certainly, for their gas to be reimbursed, but it's a reimbursement for an expense. So the employee pays for that expense and they simply get reimbursed. It's not an advantage to that employee. It's something that was in their maybe employment understanding, but it doesn't give them that advantage. Like a raise gives them an advantage of having an additional sum of money that their earning capacity can incorporate. So nor shall there be included either the cost or market value of any savings, wage continuation, wage replacement, or stock. It's funny that they had to say that, but stock acquisition programs, or of any employment benefit program which the employer pays or contributes, like a medical health care or something, to persons other than the employee or his family. So those are not incorporated in. So it's two-pronged for benefit provision. It's actual incapacity to perform the tasks usually encountered in one's employment and the wage loss resulting. That's one prong. The other prong is physical impairment of the body that may or may not be incapacitating. They have to have a physical impairment, and then they have to actually be incapacitated and losing wages because of that incapacitation. So in the injury, if the injury causes temporary total disability with disability payments at 2/3 average weekly wage during the period of disability, considering being given to ability of the injured worker to compete in the labor market, and that's still considered. In the old days, that was the only consideration, but we still look at their ability to compete in the open labor market. So we move forward. After determination of benefits due, credit for sums paid can be determined. There were some cases, and I didn't include them on this really because it would have been a very lengthy process, but I think this is an important part to look at. If the injury causes temporary partial disability, the disability payment is 2/3 of the loss in wages And that's the difference. So that's the wage loss calculation. Provided that the disability payment shall be reduced by the sum of unemployment, compensation benefits, and extended duration benefits received by the employee during the period of temporary partial disability. The reason I'm saying that is this case that I'm talking about. It basically, this injured person said, my employer paid me for the period I was off, which we would have called wage continuation in today's terms, but I still believe I'm entitled to the temporary disability for wage loss. And what it comes down to is an employee is not entitled to both. But unless you really capture the information regarding wage loss and why we would be able to recapture that, like with proper notice benefits, benefit notices and so forth, like putting on your benefit notice that we're going to take credit for the sum that was the employer already paid and we also paid because we didn't know. There's a chance that a trier of fact could say, no, I'm not going to allow you credit. The judge has the authority to not allow credit. So the point of the story is knowing the difference between active and passive income. For example, I had a case one time, and this individual had rental income, and I can tell you it's not included in determining average weekly wage. It was a little confusing. The client said, well, do we include it? Do we not include it? And do we pay benefits when this person is making $12,000 a month from rental property? But the point is that she was actually losing time from her current employer. So is it wage loss then? Well, it was determined that it's not wage loss. And here's why. The IRS definition of earnings is active. You have to be actively participating in a job, in some type of activity that you're getting paid for it to be earnings. Passive earnings are rental income. There's very little you have to do. You may be a couple occasional programs, or you may have a managing company that's doing it for you. And if that unit is returning money to you, there's not a big process. You're not actively earning. And it was a little confusing for that, but it was a good, it gives you a good example of what to include and not to include. So lost wages are not the same as calculating wage loss. Is the injured worker losing time from the employer they were injured at? And that was kind of the basis for this, passive income rental property. They were losing time for the employer that they were injured at. Therefore, they were entitled to benefits, even though they were making $12,000 a month from rental property. So benefit notices, and here's some common mistakes. I'm not sure what time we have. I think we have plenty of time left, but I'll go through. We only have not two more mini slides, but this is important. So here's common mistakes. It's important to issue a salary continuation notice to notify the injured worker the employer's continued salary is in lieu of their TD benefits. And make sure the earnings at minimum meet the average weekly wage. What I see the audit unit uncover, unfortunately, for some of these audits, is the employer says that they're giving salary continuation, but they reduce their earnings to an 85 percentile. They reduce them from their actual salary. And there may be a wage loss situation in that. So you need to make sure that there's no wage loss and that the employer is paying what they're saying they're going to pay, meaning they're paying the whole sum because they're continuing their wages. So if they were working 40 hours a week before, they're going to continue that salary. And that is a salary continuation situation. So what I always ask to do, what I advise clients to do, is when your employer says they have a salary continuation situation, as they're continuing those salaries for those weeks, get the wage statement. Get that as proof in your file, because I promise you the audit unit is now asking for that proof. They want to see if there's wage loss, because that happens quite a bit. So, and if you do not issue a salary continuation notice, it will be more difficult to take credit. Here's another thing, and the audit unit will want proof under Regulation 9814, employer program of the wage statement, proving earnings for the lost time period. The employers under 9814, a lot of us don't really pay attention to this. And I see that people have raised their hands. So let me finish this, and I'd love to have you just unmute yourself and you can ask the question. But under 9814, the employer is supposed to have a program in place. That means something in their handbook, something in writing to say, this is what you can expect. Let's say, for example, they pay for the first 3 days, they pay the waiting period. So that's their salary continuation. Let's say they pay for 2 weeks, 4 weeks. There's something that needs to be in their policy. I can tell you probably 2/3 of the cases that I've seen, there is no process or there's no program. So you have to do a good job of really documenting that. So anybody who would like to raise their, go ahead and go from a raised hand and just go ahead and unmute, and I'm happy to try to answer your question.
I think that was you, Michelle, that had your hand raised. You are muted, though, just so you know.
Hi, Michelle.
She's unmuted now, but I don't hear you.
Yeah, I'm not able to hear you. I'm not sure why. Tammy, if we had Michelle put her question in a chat, could you read that?
Absolutely.
Okay, Michelle,
Absolutely.
put your question in the chat, and then Tammy will read it to me, and hopefully you can hear me. So that will be, I'll be able to answer you.
And please, Andrea, you're welcome to just, please unmute yourself.
Yeah, in regards to the salary continuation, I have a lot of claims since we're, small mom and pop businesses. They will continue the pay, and we make attempts and document it to see if we can get some type of proof or something signed. And a lot of times we don't get that, but we do have, maybe email correspondence that the claimant and the employer are giving the salary continuation. Does that suffice on an auditing stance?
I would actually get when the employer pays, they go through a payroll agency or whatever, I'd ask them for that documentation. That's what the audit unit is asking for now. They may not have asked for that. Even 5 years ago, they really didn't pay attention to that, but now that's a big thing for them, because what they've found through the series of audits is that people aren't getting paid their whole earnings. They're getting paid less, and there may be a wage loss, and then we're not paying them the wage loss. So for your own sake, try to get that information where you're seeing that the employer is saying, here's my printed out, from my whoever pays, the paychecks. Even if it's they input in themselves and a check's issue, usually they go through some type of payroll service where you can get something printed out so you can see what the earnings are. So I would do that. I would also ask the employee, how many hours are you working? What's your rate of pay? Document that. They may say, oh, I'm working the same hours. They're paying me, the same thing, or they're keeping me on, and I'm doing lesser activities, or I'm doing something, but I'm still getting my hours. So it'd be twofold. Go to the employer and get the documentation in the form of a printout of some kind, because that really is clear documentation. And also ask that injured person, what are their hours? Are they working their normal shifts? Does that make sense?
Yes, thank you.
You bet.
And then we have another question. Michelle did put it in the chat.
Okay.
She's wondering if wage loss and salary continuation notice are issued at the same time when an employer continues paying and the employee is not being paid full wages.
They're not the same thing. Salary continuation is one notice. And what I do want to share with you, and then I'll ask the wage loss. Wage loss is a separate thing. Because salary continuation really it considers the premise that they're actually continuing their salary. So initially you're going to say, okay, they're going to do salary continuation. You know that, so you issue a salary continuation notice. Then you may find out even a few days later, a week later, that they're actually not paying the full salary. So you go into the mode of issuing another benefit letter, because the whole goal is to explain to the injured worker what they're receiving and why. So then you would say, the wage loss benefit notice, that, hey, you're losing wages. Your employer is paying you this, but you're losing these wages, and therefore we're going to pay you this sum based on this formula or whatever. So hopefully that makes sense. You can tell Tammy in the chat too, and I'm happy to expand on that.
Sorry, I was muted and I was talking. I'm sorry,
That's
Sherri. I think somebody unmuted. We've got a little background noise, just so you all know. And Danielle, I think, has her hand up next. Danielle, you're up.
Yeah, hi. Can you hear
Hi.
me?
Yes, I can. Yes, I can.
Perfect. So my question is, because, we deal with a lot of small businesses,
Yeah.
our system actually is designed to have a calculator in it.
Okay.
And just based off the beginning of your presentation, you went over a lot of if they're guaranteed 12 months and they took themselves out, we should input, like the last 5 months situation because they took themselves out of employment. Our system is actually designed, I think, to automatically pull those. Do you recommend maybe moving forward for certain cases that we just do manual calculations instead of using our system's calculator?
Yes, and I'm only saying this because if there's a circumstance that is different than the normal circumstance, I would then consider that different circumstance.
Okay.
And just to clarify, you don't have to incorporate the last 5 months. I want to be clear. If their earning capacity is, 12 months or whatever, and let's say they were missing time, they didn't work certain weeks, you could tell something happened, then that's when you really consider that. What's their earning capacity? You don't incorporate those weeks in if it's going to make their earnings lower. You see what I'm saying? You may not.
Okay.
Maybe we'll find an example. And you know what? You have my email. Let's walk through some of that off the presentation so you can have a better understanding. And I want to make sure that it's clear, because the example would make a difference.
Yeah, because you were talking about, construction workers. I mean,
Right.
We deal a lot with construction workers, seasonal employees. Obviously for certain jobs like construction workers, there is a slow season.
There's a slow season, and you can incorporate those in. Yes, absolutely.
Yeah.
You heard.
So
Yes.
I think the way our system is designed is if that wage comes in lower than an expected wage, it will remove that period. But we would want to include that, correct? Because that would give us a general average wage. And in that instance, we would want to calculate outside of our system's calculator because we want to make sure that those periods are actually included and not removed.
That's correct. Let me also talk about what I did say as well, because it's important. Let's say, for example, there was only one time that the construction worker, was off. You have to really have a pattern. So my example before is, every year about the December through January, they're off.
Right.
And in 2020, 2019, 2020, 2021, there may have been a downturn in construction. So those are repeated patterns, and they look to earning capacity. So I think you were talking about that, but I just wanted to make sure I clarified that maybe not a one-time thing. You're going to automatically, you automatically include that week because maybe there was a weird circumstance. But if there's that employer, they have slow times during Christmas or whatever holiday you're celebrating. And then they may have another time of year, like in the rainy season where there's, a few weeks they don't work. Those would be the weeks that you could incorporate because that truly is their earning capacity. So you would include them and not allow your system to just automatically remove them. I agree.
Okay. What if, obviously, if it's a company pattern, but the applicant hasn't worked there for, an extensive amount of time, but say they started in October and go through February, the company does have a past history of having a slow time during December and January.
Okay.
Would we include those dates for that injured worker, or would we remove them?
Well, I would include them, but I would also, if they've only worked there a short time, I would look to see if they had any other earning capacity as well.
Okay.
You know what I'm saying? To incorporate in. So did they have something different they were doing? So you do both, but I would include it because even if it was one time, you can prove your employer has a pattern that that every year, if they work there 10 years from the time that they started, they're going to have a slow time. So that's going to be consistent, and you would be in your right self to include that into your calculation.
Okay. And if we can't prove that type of pattern, then we would obviously remove those periods that are less than what we would normally expect.
Absolutely. Always err on the side of, what we can
Caution,
prove
yeah.
we're going to do, what I can document, what I know to be true, I can apply. And on those cases where they have a pattern and you can see, that, and you talk to your employer could give you an email saying every year, December, whatever day through January something, or, every year when it's maybe in March or April or whatever, when it's a rainy season, depending on what type of construction they're doing, we have a slow period. We have a matter of a couple of weeks that we don't have any work for them. But it is their earning capacity. And so you would document that from the employer, and you would be in a good position to say that is their earning capacity. And
Okay.
what I'll do is I will get you the 2 cases, and I will get you the way we use them in this latest audit that we were doing. And I involved my director of the appellate department, Louis Lars, and he was involved in this as well. And so I'm very confident to say, if you follow the patterns, right, and if you can document what is happening, that this is consistent for this employer because of the type of work, you can use those cases that I'll provide for you to say, no, I'm going to include those weeks in my average weekly wage calculation. And you'll be on solid ground to do that.
Okay. Now, I have one more scenario.
Sure.
Because obviously, since we deal with a lot of small businesses, what if you have an employer that is just completely irregular, like no patterns per se? It's just like when we can get a contract, we do work, right? So if the injured worker, say, has worked for a year, but maybe there's one project this month, no project for like 3 weeks, a project for a week or two, would you still consider all of that missed time in your calculation?
I would actually consider that as like irregular work. I would go into the 1, 2, or 3 to calculate that. I wouldn't necessarily put that outside of, I wouldn't put it in category 4. So I probably wouldn't remove automatically or include automatically those weeks. I would look at what what's happening. If the employer, this is their pattern and practice, but they have work, they don't have work, so it's kind of irregular. What do those people do on the times that they don't have work? They may have other earnings. They may have, work for another employer. So that you may have 1 through 3 that you have to look at to see. It's not going to be full-time regular, but maybe it would be concurrent employment, and maybe it would be irregular or something like that. So I would look at the methods and see what best applies, but I don't necessarily think it's going to be method 4 for that situation.
Okay. That's all I have.
Okay. Well, I'm so glad, because that's what we're here for. So if there's any confusion on anything I've said, I believe you should have my email. Please email me. I'm happy to clarify. I'm happy to talk through any of this with you, because I do want you to have that common understanding that we kind of talked about. I want you to have the understanding of, why do we do this? When could we do this? What should I be looking for? What should I be considering? Because then you're going to be best equipped to do the best thing you can. And if you're not clear, I'm just spouting a bunch of stuff at you, and maybe this isn't the way you're used to doing it. So you need to clarify, and I'm always available. Any other questions before I continue?
I think we're about running out of time, Sherri, so I don't know if we can wrap up.
We'll wrap up. Let me
Okay.
just continue for a few. I'll try to do the best I can to really speed up. And if you have other questions, you can email me later, or whatever you'd like to do. Okay, here's a thing that's important. Issuing a denial of TD when you have a salary continuation by the employer, I would not do that. I have people doing that all the time. Can you say, yes, well, I can deny TD? Yes, you can. But really, you want to have a salary continuation notice, because you're incorporating that for the take credit. So that beginning notice that says salary continuation, you're saying, this salary is being continued in lieu of temporary disability. In other words, if I then pay it, or if something happens, I get to take credit for that, because I'm notifying you what's happening. So don't issue a denial. People still do it. That's okay, but it isn't the preferred method. And not obtaining proof from the employer through a wage statement showing earnings, that's a mistake, paid during a salary continuation. So it's common that they don't give you information, but as we've talked, it's best to get the information. Not using the employer's date of knowledge to create your due date for a notice of benefits, delay, denial, provision within 14 days. And I still see people doing that. Not paying the waiting period if it's held in the beginning and it needs to be paid by the 28th day or with that second check. And if there's a dispute, an understanding of 4653(4)(c, subsequent benefits to be paid on the same day as the original benefit notice. So this is a big thing, and I could even probably quit with this, but if I tell you this is what's happening. There's something that's happening with the audit unit that they're saying that they were not matching the pay cycles. So for example, you send a benefit notice out and you say that someone's going to be paid on every other Tuesday. And for whatever reason, you pay on a Monday or you pay on a Friday, and it's not a holiday, which is an exception. The audit unit is coming in and you pay the full 14 days, you pay that. The audit unit is coming in, at least this last audit that I did, and they're actually changing the pay cycle. Let's say, for example, you were 2 days early. They want you to pay that benefit again 2 days early, or they're going to self-impose a penalty on you. You've already paid the 14 days. You weren't late and you didn't not pay what you owe. So we're also appealing this, Lewis is, because the labor code and the regulation doesn't say that they can do that. So be aware that they're looking for the check date to be the 14th day. It's a high standard to hold. Some people can do it, and it's great. I hope you're one that can get that 14th day cycle perfect. But most of the clients that I've dealt with, myself included, when I was an examiner, there'd be some times where maybe you issued a check early. And prior to this audit, I've never seen that in my 38 years. So just be aware that could happen. If you have it happen, let me know because I'll help you walk through it. So there's some more here. I'm going to let you'll have this PowerPoint, and I think, well, we're pretty much done, but 2-year rule, you want to pay attention to that after 2 years, you need to look at what their compensation rate is. So that is it for me, and it's been a pleasure, and I hope that I got enough information to you that you have a better understanding. But please, again, clarify with me.
Thank you all so much for jumping on, even though we had a little time issue there, but you were all still able to jump on, and we're very thankful for that. I did record it, and I will share that video, the video link with you later today, hopefully, maybe tomorrow, Michelle, but I will get that over to you so that anybody who missed can watch. And you do have Sherri's contact information there if you guys have any questions for her. She's the best. And Happy New Year, everybody. I hope your January is going great. And I hope we are going to see you. We're going to see you later this month for part 2. So it is at 10 a.m. and we are looking forward to seeing you guys on the 27th at 10 a.m. And thank you. Thank you so very much.
Thank you so much.
Take care, everybody.
Tammy. Thank you,
Take
Sherri.
care.